Well, good afternoon to all, and good afternoon to our panelists. Welcome to the last session of our annual Missouri Federalist Society Chapters Conference. The online one, hopefully next year, will be in person. It'd be good to see people in real life again. But this one is on changes to the pretrial release procedures. In 2017, the Missouri Supreme Court created a task force on criminal justice to ensure that the determination and conditions of pretrial release are based on risks of failing to appear and dangerousness to crime victims, communities, or others, and not on race, gender, ethnicity, or economic conditions. The task force is comprised of stakeholders from all over the state, including prosecutors, judges from municipal court all the way to the state Supreme Court, criminal defense attorneys, myself included, and others like the director of the Department of Corrections, the director of the Department of Insurance, and more. Today, to discuss changes to bond and other work of the task force are our panelists who co-chair the task force, along with Judge Mike Noble. We have Amy Feit, who's Christian County prosecutor. She finished a 2-year term as president of the Missouri Association of Prosecuting Attorneys and is currently on the board of that organization. She finished her term in 2018, and J.R. Hobbs, a criminal defense attorney who has long served as a board member on various organizations as an advocate for criminal defendants. They're going to address today the ongoing issues on the development of pretrial release and bond rules, ongoing issues in the development of, pretrial release, that's in there twice, continuing issues with risk assessment tools, and an overview of ongoing litigation and concerns. Audience members, feel free to submit your questions throughout this presentation, and we will take them up throughout. Use the question feature in the Zoom window. So with that in mind, JR and Amy, you've been involved from the very outset in providing input in your roles as co-chairs of the Task Force on Criminal Justice and the development of the so-called new bond rules. Drawing on that involvement, as well as your experience in the trenches, what tips can you share to ensure that all factors are being fairly considered? JR, could you lead off with some observations about the new bond rules, including a brief history and reasons for the changes and that we are now considering and implementing?
Sure. Thank you very much, Jennifer. Interestingly, from its earliest Anglo-Saxon roots, bail was initially only concerned with flight risk, not danger to the community. Judges set bail in amounts equal to potential fines rather than using it as a tool for detention or concern about the community. In fact, the early colonies created liberal rules in all but capital offenses for release. And Section 33 of the 1789 Judiciary Act was the model. Until at least the 19th century, the federal judiciary treated bail as synonymous with release. One of the seminal cases is United States versus Barber out of the United States Supreme Court in 1891. And the debate was about the scope of whether bail restrictions were excessive in terms of an Eighth Amendment analysis. Now, the concept of bail as a tool to assure appearance was reflected in Supreme Court cases, at least through 1951 with a case called Stack versus Boyle. And in Missouri, there's a very interesting history of bail set out by Judge Stiff in 2012 in a case called State versus Jackson, where she noted even early on, ironically enough, that the development of bondsmen was pursued due to a belief at the time that that would help eliminate racial and ethnic concerns and would be more fair to all. Now, the tide began to change in about 1952 in a case called Carlson versus Landon. And then over the next several years, the Bail Reform Act in the federal courts changed things significantly. The Bail Reform Act authorized courts to preventively detain a person pre-trial if there was no condition or combination of conditions that would assure that a person was not a flight risk or that the person was a danger to the community. that set of statutes that set out at 18 United States Code 3142 was upheld in a case called Salerno, which held that it was all right to consider those considerations, even if one was temporarily detained before a hearing held, and it did not offend the notions of due process and equal protection under the 8th Amendment as well as the 5th Amendment. And then Missouri, like other states, began to do changes too. In 1992, the Missouri Supreme Court had the Constitution was amended to allow the provision constitutionally that the position of victims of crime safety could be considered as a condition of bond. So for our purposes, what then developed after Salerno in 1987 and after the advent of victim rights legislation was a system of bond that took in these considerations. The federal system changed the landscape significantly. When the bond rules were promulgated by the Supreme Court here recently in July, I believe, 2019, you'll note that there's still cash bail, but that cash bail, if it's used, is supposed to be tailored to the economic circumstance of an offender. And the reason for this task force was that there was constitutional concerns. They were raised in a case called O'Donnell versus Harris County out of Texas. And even in the Eastern District, Missouri, there's an ongoing case called Missouri versus Dixon that says if you do not tailor money bond to an individual's economic circumstance, that could offend notions of due process and equal protection. And some of those issues are even tied to some of the community issues that we saw in Ferguson. And so there's a lot of debate about that led to the new rules. As you pointed out, Jennifer, there's a lot of stakeholders that made their ultimate recommendations that ultimately went to the Missouri Supreme Court. The new rules do not eliminate a cash bond, but they do set out practices that are supposed to be followed to assure a more fair system for all.
Amy, can you respond to how the new bond rules have affected criminal bond practices from your point of view and from what you've seen? I know that like in Boone County, it used to be like, if you get arrested for this, your bond's this. There was no individualized determination based on, various circumstances at that point, at the point of arrest. So please share with us the changes and how it's affected things from your point of view.
Sure. So from a prosecutor's point of view, I think some of the major changes that we have seen have to do, some of it is just time. So from the standpoint of previously, if you filed a charge, you may have filed a charge. And even if you were making a request with regards to what you believed would be an appropriate bond, there wasn't necessarily a lot of information that went with that. So at this time, if we're asking for an arrest warrant, we're filing a motion every time we ask for an arrest warrant, along with recommendations, so that there is the opportunity for the court to be making those individualized types of considerations, so that they can take into consideration the probable cause statement. They can take into consideration what information might be available with regards to a defendant's criminal history, or if there's any information with regards to statements about appearance or non-appearance, or statements with regards to threats to the victim or to witnesses at the time that the incident occurred, those types of things. So from just kind of an anecdotal observation, it's much more time intensive for us, because you're seeing basically a motion every time we request an arrest warrant, which would be a new practice that we've put in place. You're also seeing, and I know we'll get to it in a little bit, but just from the standpoint of, you've got the initial appearance and then you have the 7-day hearing. And so everybody who is confined, we're also spending a lot more time with regards to appearing and making bond arguments than we were necessarily doing before.
Is that lengthening the time that people stay in jail initially? Because with like bond schedules, you could pretty much find out right after you got arrested because you knew the amounts. Is this causing some sort of delay in the amount of time it takes people to get out?
So from the standpoint of practice-wise, I mean, the court is still setting a bond just like they would have before. So not every jurisdiction had bond schedules. I know some jurisdictions may have done that. That was not necessarily something that was done here. And my understanding is that the manner in which a bond schedule would be used is that that's something that could be used before an arrest warrant was issued, so that somebody, like, if I'm understanding that correctly, like a person in a jail could be looking at that and going, this is what the bond will be. So somebody could go ahead and make a bond whether or not an arrest warrant had been issued. Many jurisdictions didn't have that practice. And so if you didn't have that practice and the person was held for the 24 hours on the probable cause arrest, if a warrant was issued within that 24 hours, then the judge had already set the bond. So as far as the judge setting the bond, there was really no difference in time.
Well, just because we're not all criminal law practitioners here, maybe could you walk us through, like, what happens if a police officer makes an arrest? When does the arrest warrant happen and the bond and stuff like that typically now?
Sure. So looking at like the way it works now, an officer makes a probable cause arrest. So if an officer made a probable cause arrest and it's 3:26 p.m., they make their arrest right now. Then within that person can be held on that officer's, under the laws in the state, current laws in the state of Missouri, that person can be held for up to 24 hours based on that probable cause arrest. That person cannot be held for more than the 24 hours unless there is an arrest warrant that is signed by a judge, that then puts into place that there's been an arrest warrant signed by the judge. When the judge signs an arrest warrant, the judge also then makes an initial determination with regards to a bond setting. Generally speaking, unless they're going to make unless their initial determination is that they're going to detain without bond. So then once that bond is set, then under the current rules, it would be within 48 hours of that the arrest warrant. So within 48 hours, excluding weekends and holidays, of that arrest warrant, that individual must be seen by the court for their initial appearance. And then the court at that time can tell them what the bond is, what the conditions of bond are. And then subject to the right of a victim to be notified and heard, there can be modifications to that bond. If the person remains confined, then within 7 days, also excluding weekends and holidays, but within 7 days of that initial appearance, that person must be seen again by the judge. So the only thing that's really different now is that it used to be that the presumption was for a felony, the presumption was that that was an arrest warrant. So if you had a felony, you presume that there would be an arrest warrant that would go out. Now the presumption basically is that there's a presumption for a summons unless the court has reasonable grounds to believe that the person is a flight risk, or they have reasonable grounds to believe that they pose a threat to the community, to the victim, to the witness, or any other person. Then if that were the case, then an arrest warrant shall issue. Is that, I don't know, Jennifer, am I answering your question, or is there more information I can give you on that?
No, it makes sense to me. I think I've just used the schedules, the bond schedule, where, it was set at a certain amount and then you didn't have to wait for various parts of the paperwork to get processed necessarily for regular run-of-the-mill things, that the prosecutor wasn't going to file something special requesting a deviation from that schedule. But I believe that some of these challenges around the country were based on, look, if you're just setting bond schedules, that's just a financial condition, that you're not considering the economic circumstances of the person or flight risk or danger to the community. So that's, not constitutional.
Right. And so not every jurisdiction was doing that. So bond schedules were not, while you may have experience with bond schedules, not every jurisdiction was that a practice.
Yeah. The one thing about Missouri is, like, we have 114 counties and 114 different ways of doing things. It seems like from serving on these committees over the year, I find out. JR, so we are supposed to be looking at individualized circumstances and whether detention is appropriate. Is detention appropriate if you're just concerned that they won't appear and not that they won't be, that they will present a danger?
No, the new rules do not envision detention on the sole basis of appearance. If a prosecutor believes that detention
is appropriate, and that's a change, right?
It is a change. As a practical matter, in the old system, a bond might have been set at $250,000 with the notion that most people wouldn't make the bonds. You're effectively detained. Now there's two standards. One is appearance or flight risk. The idea being that particularly in lower level felonies, we shouldn't set $1,000 bond, even if most people might be able to make it, particularly with a bondsman, because flight risk is not a reason for detention. If there's a reason for detention, there is a motion filed, and the prosecutor must show it by clear and convincing evidence that that defendant is a danger to himself or the community. And there's a hearing, reliable hearsay is allowed, proffers are allowed. It's not a lengthy hearing. That can be anywhere from 15 minutes to an hour in most cases. And if the court believes detention is proper, it's only because a finding has been made on those standards.
Amy, as a prosecutor who occasionally goes to other circuits, can you briefly, we were kind of touching on this a minute ago, but can you briefly compare and contrast any practices of setting bonds between circuits that you've observed?
Sure. So our office, we get appointed to serve as special prosecutor at times in different jurisdictions, and that's kind of how I've had the opportunity to be in different places. Some of it is just practices, just like you would have seen before. So some judges are on the record, and there's a recording of every time somebody comes in for an initial appearance or a 7-day hearing or any bond review. That is always done on the record and it's recorded. Other judges have, like, for instance, like a checklist, almost like a form, and they're making written findings. So all of it is information that goes into the record. So there's still a record of what's occurring. Probably the biggest distinction, it just has to do with the manner in which they're making the record.
JR, from your view, have the new bond rules effectuated any real changes in terms of whether defendants are getting out on bond, or how fast they get out on bond? And are there any statistics on this topic?
Well, first, as Amy has talked about, the processes and procedures are definitely different. And one could argue that it's a step in the right direction because we don't just rotely, without an understanding of a person's economic circumstance or their background, just set something arbitrary. That process is definitely different. Now, to the question of, well, are more people being released or held? That is a good question with a difficult answer. OSCA and other groups, sheriff's associations that participate and give meaningful information to our task force are trying to think of ways of gathering that information more than anecdotal to be able to answer it, because we too want to know. I would say that it appears that on lower level offenses, there is more use of signature bond, recognizance bonds, because if you believe the case law and the edicts that are being made in these cases, that should be done, or you're under threat of having a 1983 action filed against your court, your procedures being subject to that sort of argument. On the other hand, it's hard to say if more people are being detained, because you'd have to compare how many people, in my example, can make the $250,000 bond to how many people are detained. And so it's a good question. We're still trying to develop information on that, because it takes us to these new things that we're looking at, risk assessment, pretrial service agencies. It's better to have more data on that before we complete our project.
Well, on that, I mean, as the appointment of public defender, I'm a former public defender, and that seems like a very compressed timeline to all of a sudden be ready to proceed on a 15-minute to an hour-long hearing. Are these people that are detained represented by counsel at that hearing, Amy?
Frequently, it would depend. So some are, if they have retained private counsel. If they are someone who is applying for the public defender's office, these hearings are frequently done with them not. The initial appearance would be done without them having counsel.
But there's a right to a review hearing 7 days later, right, and the counsel will be appointed there.
And it's
I guess one thing to add, Jennifer, is you hope that there's not a problem from the outset, but at least you have the opportunity for a meaningful review. And if one looks at Rule 33.01, there's many factors that a court must now consider, or they're subject to a writ. And those factors are set out, including ties to the community and things that are common sense, but they're set out in a way for court. Some courts have forms that make them go through that analysis.
Mm-hmm.
Amy, how often are some form of cash bonds or surety bonds still used by your circuit? Also, how do you efficiently but effectively go about the task of tailoring the money bond component to an individual's economic circumstance?
So with regards to the cash and the surety bonds, as JR has already mentioned, in some ways you're seeing, at least initially, you might see less of those. So where maybe previously somebody would have received, JR used the example of $1,000. So $1,000, $2,500 bond, let's say for a lower level felony, they may receive an OR right now, or even a summons right now, where you're then going to see the cash.
And an OR, just because a lot of our members are not practitioners, so you want to just tell them briefly what the difference is between cash and surety and OR? Okay.
Sure, I apologize.
No,
so cash would mean that somebody literally is putting up cash. So it may be that the bond is set at $250 cash or $250,000 cash, and somebody has to come in and literally they're putting up that amount of money. If you have a surety bond, that's where you often, it doesn't have to be a bondsman, but you often see it as a bondsman who's coming in and basically saying, I'm good for the 200, like somebody has paid them money and they can do, like, sometimes you'll see a bond, $2,500 cash or surety. So somebody could put up $2,500 cash, or somebody could have a surety, somebody who's going to come and basically sign for them and say, I will be responsible for the $2,500. In that case, then
and the person pays the bondsman like $250 for them to do that for them.
Right. And so frequently you see like 10%. So somebody pays a bondsman $250. The bondsman then comes in and the bondsman signs that they will be responsible for the $2,500. Then if the person does not appear for court, then the bondsman, they, instead of having to pay the court the $2,500, they may go and get the person, be responsible to go and physically get the person and bring them back to the court and present them to the court. The OR is when you are released on your own recognizance, which means like I'm signing for myself. I am making a promise for myself that I will come back and I will appear in court. There's no money that goes down. It just means that I'm making that assurance to the court on that I will appear again. I think that covers your questions about the different types. Mm-hmm. Then your next question was, do we still see those? So where in the beginning yes, we do still see them. They haven't gone away. The bond rules did not rid us of cash or surety bonds. It just, as JR has already outlined, has made it so there's all these considerations that a court must do first. Their presumption is going to be release. Their presumption is going to be release OR. Then they have to make a finding that there's reasonable grounds to believe that they won't appear. There's some other things that they have to put in place that are, so they might put them on GPS. They might put them on a mobile check-in app. There's a variety of things that they can do. But where we do see it often is somebody may receive an OR or they may be released on a summons and then they don't appear. And so then they get then when they haven't appeared, because, and I know we don't have the numbers on that, unfortunately, we can only speak anecdotally, and COVID has also made a big challenge with regards to probably being able to look at numbers and draw good information from the last 12 months. But ultimately, that is a question that would need to be reviewed. And then what you're going to see is when people have failed to appear, it's now becomes much more common that you're going to have some type of surety put in place, like a surety bond, because the person has demonstrated that the least restrictive means, which was just being released OR with a promise that they're going to follow the court's rules, they're going to appear for court, they're going to obey all laws, they're not going to tamper with a victim or a witness. They didn't comply with that. And when they didn't comply with that, then we did need to consider another form. And so then that's where you might see the cash or the surety bond. With regards to tailoring it, what I have seen courts do, and sometimes we may have information during, if that information came out during the course of an investigation, but not always are we going to know, like, is somebody employed or are they not employed? We won't necessarily know that information. But the courts frequently are asking people at these hearings, are you employed? Do you believe you can make, if I set this bond at $5,000, do you believe you would be able to make that bond? Tell me what your ability is. So they are being asked questions to help guide the court with regards to what would be appropriate to tailor it to the individual economic situation for the person appearing in front of the court.
JR, speaking of COVID, we're implementing these new rules when courthouses have been closed this past year. Any observations you've made as to how, the setting of pretrial release has gone during COVID, and even like no shows to court, failures to appear? Are they getting warrants for not logging in for their court appearance?
Sure. Again, bail rules emphasize two things. Are there a condition or combination of conditions to avoid a flight risk and danger to the community? Now, the impact of COVID has resulted in a couple of things. First of all, many hearings are done virtually or by video. And while it's not a requirement or even a listed category within 33.01, I think it's safe to say that there might be a more use of signature bonds or lesser restrictive considerations if the only consideration is appearance at court, so as to avoid health issues in the community or within the detention facility. I think you are seeing some of that.
We have a question from our member, Judge Debbie Daniels. Do preset bond schedules still work, and are they still used?
Yeah, I would, to my knowledge, they would not be, because you're not going to be complying with the, and I'll also listen to JR's answer to this as well, but I would believe with the new rules that would not be possible to be using a preset schedule. Like, in other words, the determination, you might have a misdemeanor. You could have somebody who's arrested on a domestic assault fourth, and presumably under these bond rules, based on your observation of the whatever facts and information you can provide, and when the court goes through its analysis, it might find that no bond is appropriate, even though that's a misdemeanor case. You also could.
That's new, right? Like, usually,
you previously,
I didn't see it.
Previously, you had to go through steps if you wanted to get an arrest warrant on a misdemeanor, and in some ways it's somewhat similar, but that would be the idea, is that it should be unique to the person, to the facts and the circumstances of the case, and that bond should be set that way. It shouldn't be, I have a possession of controlled substance case, it's a possession of controlled substance, it's a class, and now they're D's where they used to be C's, but it's a class D felony, and therefore the bond is now set at $5,000 cash or surety, because that's what we do with the possession of controlled substance case. That bond should be individualized, and there should be an individual determination. So having some type of set bond schedule that does that, where it goes, well, this is an A felony, therefore the bond is X, it's a B felony, so the bond's this, those wouldn't be in compliance with the current Missouri Supreme Court rules, in my opinion, but I will defer to JR to hear his.
Yeah, JR, thoughts on bond schedules?
I concur with Amy. Rule 33.1 allows us to set a bond considering the least restrictions possible.
Right.
If you're using a rote bond schedule, you're not considering the least restrictions possible. And there's a litmus test on, if you do consider money to be one of those components, then one must go through some process to tailor that to the individual circumstance. Interestingly enough, just last week in the Missouri Law Weekly, they reported an update. I haven't read the actual opinion yet on the update of our Eastern District of Missouri case, which was Dixon, Missouri versus Dixon. And what they initially held as, well, the new bond rules might obviate the criticism that Missouri practices are violating equal protection due process. Now the court has remanded it for a hearing to make sure that the new bond rules are in fact being abided, that they're not just having a set schedule, still using it, and not really considering 3301. So they're live and real considerations.
One thing that we discussed, especially in early days of the task force, is that it kind of cut both ways. You had poor people that were being held for a long time in jail just because they could not afford to bond out, not necessarily because they were a danger. And you also, which Amy, I think, alluded to, you had people who had the financial means to get out that might actually be a danger to their victims. And if they had the financial means, they were out. Amy, any observations about, of the change and how that is affected?
So I think from that standpoint, that is something that we've seen that is different, where previously, at least the practice, you might have a very horrific sexual offense case, and maybe you would come in and ask for a $250,000 bond or $100,000 cash bond or $100,000 cash or surety bond. And you were right, Jennifer. Sometimes there were people who could make that. And so they would make the bond, and that wasn't in any way addressing the danger they posed to the victim or to other members of the community. And so now what you're going to see is we are far more likely, we're not going to go in and ask for a $100,000 or $250,000 bond. We're going to go in and ask that the person be held with no bond. And we're going to set out why we believe that we can show that by clear and convincing evidence. And so you're going to see, which I'm kind of jumping, but when we had the original in the task force, when all of those groups who had already done something similar had come in, it was like they were telling us, you're not really going to probably see a reduction in your jail population. What you're going to see is a change in who's in your jail population. So you're going to actually getting a greater concentration of more violent people being held pre-trial than maybe you had before, where you might no longer have, for instance, like the person who couldn't had a small bond made on a misdemeanor possession of marijuana or a misdemeanor possession of drug paraphernalia case, that your jail space is going to be utilized for the more violent people while they're awaiting trial.
Amy, also, I wanted to ask you, how are victim rights taken into consideration? And with regard to these virtual hearings, are they still able, as required under the rules, to voice their concerns or be heard with regard to the pretrial release?
So the answer is yes, and certainly just as people have had to do a lot of things logistically different the last 12 months, it's been no different for victims and witnesses. So we've done a variety of things. Sometimes people have been allowed to appear by phone. Sometimes we have people in our office, but they've been, but they're on WebEx here. If they don't have access, in order to be able to access the WebEx, we may have to have them here in our office, but that's how they're being heard in a courtroom who is having court via WebEx. So there's been ways to, certainly been ways to accommodate that, but that has been a challenge particularly with COVID, that has been a challenge.
Before we move on to the risk assessment tool, I wanted to ask you both what kind of pushback. We've mentioned bondsmen. I'm sure they're not that pleased that a lot of this reform is happening, but what kind of pushback or complaints or concerns are you hearing about these new changes and forthcoming changes? JR?
Well, I've been advised that there's some effort in some situations to bring litigation on behalf of those groups to argue that their system does respect the rights of due process and equal protection. I think, again, that's going to be an ongoing debate as we ferret through these rules that we're seeing in the Dixon case.
Amy?
Probably, yes, there certainly have been some groups who were impacted by this change in the bond rules, who have certainly made
It'll affect their livelihoods, obviously.
Yeah.
So
it's the same issue that affected federal court. You see less bondsmen used in federal court because they had a rule similar to this for some time. But occasionally bonds, if they're approved, and standard procedures and protocols might be called for as well.
All right, so I wanted to move on to this risk assessment tool that is being tested. Could you please, JR, share with us what constitutes a risk assessment tool and specifically address the Arnold Foundation PSA tool?
Sure. Pretrial risk assessment tools are basically mathematical recipes that group people into risk categories. And there are two types of these tools. One's called an actuarial algorithm, and some use clinical interviews. In an algorithmic assessment, the tools are based on outcomes from historical data. And their objective is to look at patterns of past data and correlate that in terms of condition of success. That is, were they a flight risk, were they a danger during the pretrial context.
Yeah, will they reoffend while on bond?
Correct.
Right.
And
Okay.
so there's a risk score that's given. Now, to answer your question, the Arnold Foundation PSA tool is the tool the court has adopted when it's eventually validated in Missouri. Amy will speak to that. But the one reason that tool was adopted is that that tool separately predicts risk of failure to appear, risk of arrest, risk of arrest for violent crime. It doesn't give us one combined score. It gives sub-scores so that a judge can look at that. And then again, as touched on in Rule 33.01, it's just one factor. Broadly speaking, the validation is required, and one of the reasons it's required is to make sure it works in each locale in Missouri that it's hopefully going to work in, and to make sure that the risk assessment tool is not one that discriminates against people. There are people who have written, I've read an article, The Champion, it was published in June of 18. That's a magazine put out by the National Association of Criminal Defense Lawyers that's concerned about our risk assessment tools, since they're based on historical data, is that then prone to bias against minorities? And so that is a type of thing that's being looked at. There's some that argue that risk assessment tools by design over-predict risk since they're relying on historical data. But that's essentially what it is. It's not tailored to the individual defendant. The algorithm is tailored to